attorney, to have one appointed if you can't afford one. You have a right to bail, and to make the state prove any charge against you beyond a reasonable doubt. If you're not sure of what you should do today, not guilty is always the safest plea you can enter because it preserves all those rights. If you enter a guilty plea or no contest plea, you're waiving those rights. So if you want to have a lawyer, talk to a lawyer, you haven't been able to do that, you should enter a not guilty plea, or if you want a trial on your case, or if you don't know what to do, you should enter not guilty. Call the first case.
State of Ohio versus Ryan A. McKenzie, case number TRC 24006, A, B, and C. Ryan McKenzie.
Ryan A. McKenzie was cited in court for this Friday, so that's probably why he's not here today. So I'll pass it till Friday, January 5th.
State of Ohio versus Garner Stevens, case number TRC 24005, A and B.
Garner Stevens is also cited in court for this Friday, January 5th. Not for today. I'll pass till then.
State of Ohio versus Shelby Sprouts, case number TRD 191068, A and B.
And ma'am, are you Shelby Sprouts?
Yes.
Okay, this was set for a sentencing hearing on the 29th of December. Apparently you were not here at that time.
Yeah, I had COVID. I called that morning and she told me to come today.
Okay, this is on a license issue. It's an older case. So you were given some time to try to get your license reinstated. Have you been able to do that?
Not yet. I need to get a permit first.
Okay. Well, I'm just going to go ahead and sentence you because this is a very old case anyway, so. Because you had failed to appear back when the case was originally filed in 2019, and then got arrested in November, correct? November of this year on a warrant. The officer, back at the time this was issued, says the defendant was observed traveling east on US 52 above the posted speed limit. Computer radar check showed the defendant was 57 miles an hour and 45 zone. Stopped the defendant. She was unable to produce a license. A check through the computer showed she had failed to reinstate her license. So that means your license had been suspended, that the suspension was over if you never reinstated it. So at this time, you never did get them reinstated. You have to retest.
I just never had a license before.
Okay. So you must have had a suspension. I'm looking at your record. It looks like you had a suspension and the suspension was up. So, all right. So you never did get a license. Where are you living now? Are you still in Ironton?
Yeah.
Working?
No.
Kids?
Yeah.
How many?
2,
How old are they?
3, and 5.
How do you get around to take care of them? You got a lot of stuff to do with kids at how do you manage that?
My boyfriend.
Okay. Have you ever even taken the test?
No.
Okay. You don't want to get a license then?
No, I do.
Well, it's been 4 years now, so
Yeah.
I mean, you've had a lot of time to try to get one. Okay, I'm just going to go ahead and sentence you on this. On the failure to reinstate your driving privileges, I'll impose a $75 fine and order you to pay the court costs On the speed offense, I'll impose a $20 fine. Do you need time to pay that?
Yes, sir.
Okay. I'm going to give you, here's the way it's going to work. I'm not going to put you on probation or anything like that. I'm giving you till April the 9th to pay it, so that's quite a while. We're going to call that a final pay date. So what's going to happen if you pay it before April 9th, it's going to go in on your record, but we're not going to issue a suspension. If you don't pay it by April 9th, I'll notify the B&B and have them suspend you. You don't have a license, but you won't be able to get a license because you'll be suspended because you didn't pay this by April the 9th. Okay, do you understand what you got to do?
Yeah.
Okay, if you want a copy of the judgment entry that we're typing up, she's typing it as I'm telling you, and I'll sign it, you can get it from the probation. I'm not putting you on probation, but the probation department can give you a copy of it. To the left when you leave the courtroom. You can look this up if you have a question, if you have a smartphone or a laptop or a computer. We have a website. Anytime you have a question about it, you can either call in or you can get online to the court's website and check your record and see what it says you're required to do, because it's going to be there. Any questions?
No, sir.
Okay, that's all. You're free to go.
Thank you.
You're welcome.
State of Ohio versus Sean A. McComas, case number CRA 24-2.
Yeah.
And sir, you're Sean Andrew McComas.
Yes, sir.
How do you spell your last name?
McComis.
Okay, you need to spell correctly on here. Mr. McComas, it's alleged that at Rome Township on December 30th of 2023, you not only caused or tried to cause physical harm to Jacqueline Ann Caldwell, and that she is either a member of your family or household.
Yeah, she lived with me. It's not true.
And that the victim was pregnant at the time this occurred, so that makes it a felony 5, maximum penalty is a year in jail, $2,500 fine.
Mm-hmm.
You understand the charge?
I understand. But I'm not
Still
guilty.
wanting to proceed with this?
No.
Well, he's the state, not you. It's the prosecutor. I'm asking the prosecutor if they want to proceed.
We do want to proceed.
Okay.
I'm sure that this young lady behind me has something that she wants to say about it, but
Okay, well,
at this
let's
point,
talk about getting you counsel or bond, and those two issues. Do you have a job, sir?
Yeah, I do.
What do you do?
I'm a cook at Waffle House.
You're a cook at
Waffle House.
a Waffle House, so you pay by the hour?
Yeah.
How much per hour?
16 right now.
How many hours a week do you work?
About 36, 38.
I didn't want to do it, and I'm not good.
So you're making about $30,000 a year roughly at that. So I have to determine your gross annual income. That's what the Supreme Court
I'd say
does.
so. I haven't been a full year there, so I'm not sure yet.
Okay. Do you have any, I understand she's pregnant, but do you have other children?
No.
You have no children? All right, well, you're actually over the limit for assigned counsel. What's the state's position on bond?
Ms. Caldwell is not interested, I don't believe, in a protection order. And we're not opposed to an OR bond. We're not ready. He may have already posted a bond.
He has a bond up, that's correct. Okay, so here's what I'm going to do. I'm not going to assign counsel for you because you make too much money. You're welcome to hire a lawyer, but that's up to you. But I've got a guideline I have to go by as to appointing a lawyer. For a single person, you're making more than what's allowed. She doesn't want a protection order, so I assume you all live together.
We did, yeah. We did live together.
Okay. This is filed as a felony. I don't know if the state will continue to pursue it as a felony. in light of her position on this. So you have a right to have a preliminary hearing within 10 days. That's the next hearing on a felony case is called a preliminary hearing. Or 15 days if you're out of custody, so which you are going to be out of custody. Do you think you can get a lawyer in the 15 days?
Yeah, I think I can.
Okay. I'm going to let you sign a signature bond of $1,000. Oh, that's right. You have a bond up, so we don't need a signature bond. So I'll just continue the bond that you posted. No protection order, as Jacqueline's requested. And I'll set your next hearing for the 13th. Looks like. Let me check that date.
The 16th. He's gonna tell you in just a second.
Well, it actually would be the 12th, not the 13th. Okay, so that's when I'm going to set it. January 12th is your next hearing. That's a week from this coming Friday.
Okay.
And that'll be at 10 a.m. Any questions?
No, I don't.
Okay. January 12th, 10 a.m. is your next hearing.
Okay, thank you.
State of Ohio versus Alexander C. Altizer, case number CRB 24-1.
Yes, sir.
You're Alexander Altizer?
Yes, sir.
Mr. Altizer, you have a disorderly conduct charge filed against you. It's a minor misdemeanor. The good news is it's not a jailable offense. The maximum penalty for it is a $150 fine if you're found guilty. It's alleged that on January 1st in Rome Township, you recklessly caused inconvenience, annoyance, or alarm to others by engaging in fighting, threatening to do harm to other persons or their property, or being violent or turbulent. That is, as I said, a minor misdemeanor. Maximum penalty is a $150 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Guilty.
Guilty means you're admitting it's true.
Yes.
Okay, I'm going to read the affidavit that was filed with the charge. It says January 1st, 2024, I was dispatched to an address, Crown City mailing address, in response to a call for domestic violence. While en route, was informed the female had ran to a neighbor's house. When I arrived, the front door of the house was standing open, and I observed two males inside. One identified himself as Devin Poole, who lived there, explained that his buddy was drinking and celebrating New Year's Day when an argument escalated. Alexander Altizer was sitting on his wife, Heather Poole. Devin and Alexander had a physical altercation. Devin struck Alexander above the right eye. Alexander was covered in blood. Hearing the two men fighting, Heather ran to the back bedroom, hid, attempted to contact 911. Devin took her cell phone and asked for her help to clean up the mess. Heather left the house, ran to the neighbor's house, called 911 while standing in the living room and spoke to dispatch. When I arrived, I secured Devin in handcuffs and put him in my vehicle to separate the parties and bring in EMS to assess Alexander's injuries. Alexander was bloody and irate, not answering any questions. Alexander was asked several times where his wallet was, and what his name and date of birth were, and he refused to answer. At one point, walking toward the front door in the home, he attempted to leave, and had to be restrained, placed in handcuffs to allow EMS to check his wounds. At that point, he was then arrested for disorderly conduct, resisting, was cleared by EMS, placed in the cruiser. Sergeant Sisler secured pictures and a witness statement. Anything further from the prosecutor?
Well, the explanation there, the narrative includes something about resisting. And we do have this is not here. This is an original affidavit.
I assume since I don't have that charge, that I'd have to decide not to pursue the resisting arrest. Or...
It's possible that it was overlooked, and I'd like to, if I may, just read this over a little bit.
Okay. Let me do this. Mr. Altizer, have a seat. I'm going to let the prosecutor review the file, then I'll call you back up and see how they want to proceed.
Has he got resisting?
Okay. Let's hold off on that so he reviews that.
State of Ohio versus Ronnie G. Tawny, case number CRB 24-4.
Is it pronounced Rainey, ma'am?
Rainy, yes.
You're Rainey Twine?
Yes.
Just stand up,
Oh,
please.
sorry.
You have a charge filed against you for theft. It's alleged that Fayette Township, on December 29th, you tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor theft offense. The maximum penalty for that is 6 months in jail and a $1,000 fine. Do you understand the charge you filed against you?
Yes,
Do you understand the rights you have as a defendant?
yes.
How do you wish to plead to this charge?
Guilty.
Guilty means you're admitting it's true, and you're waiving your rights to have a trial and have a lawyer on this charge. Do you understand that?
Yes.
Okay, so what I'm going to do, because typically it's not just for you, we do it on just about every shoplifting case we get, because I get a really high percentage of people that test dirty. I'm going to order you to do a urine screen. So go do a urine screen. After I get the results of that, I'll have you back up and I'll do the sentencing. So Mr. Mint will help you with getting that done. So go out in the lobby and I'll show you where to go to do your urine screen.
State of Ohio versus Andrew Carr, case number CRB 24-7.
So are you Andrew E. Carr?
Yes, sir.
They'll just hand you a copy of the charge, which is a theft from Walmart also. This alleges that December 29th, 2023 in Fayette Township, you tried to deprive Walmart of property without their consent. It's a theft charge, maximum penalty 6 months in jail, $1,000 fine.
Yes, sir.
Do you understand the charge?
Yes, sir.
And you understand the rights you have as a defendant?
Yes, sir.
How do you plead?
Guilty.
Guilty means you're admitting it's true.
Yes, sir.
I'll accept your guilty plea. I'll order you to do a urine screen. So go out in the lobby, make a left turn towards the probation office, and they'll direct you where to go to do your urine screen.
State of Ohio versus Rosa Hamrick, case number CRB 24-5.
Ma'am, you're Rosa Ann Hamrick.
Yes, sir.
They'll just hand you a copy of your charge. It's a theft offense from Walmart, alleged December 30th, last year, 2023, in Fayette Township. You attempted to deprive Walmart of property without their consent. Maximum penalty 6 months in jail, $1,000 fine. You understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead?
Guilty.
Okay. And you understand that means you're admitting it's true?
Yes, sir.
Okay. I ordered you to do your urine screen before I sentence you, so go do that. Come back, we'll sentence you after I get the results.
All right, thank you.
You're welcome.
State of Ohio versus Trevor Fitzpatrick, case number CRV 23-232, A and B, and TRC 23-379, A and B.
All right. Trevor Fitzpatrick is here. He had a review hearing on December 22nd. And Celeste, you missed that hearing, is that correct?
Yes, sir.
Do you have an explanation for missing?
Yes, I had COVID.
Okay. And it looks like you've done some of your community service since the last hearing.
I'll have to verify, Your Honor, I don't remember off the top of my head.
Okay, yeah, well, there's a note in the file that you had. Do you have a payment on your fines today?
I could.
Okay, how much are you paying?
I could pay $100.
All right, make your payment. I will not issue a warrant since you came in today, and you did community service since your last hearing. Are you working now?
I'm still just doing odd jobs till I go out of town.
I'll set your next hearing for February 12th. That's a Monday. February the 12th at 9 a.m. will be your next hearing. Okay.
Sounds
That's
good.
all.
Thank you.
Yes, sir. Okay, we're going to go to the jail now by teleconference for some hearings.
State of Ohio versus Chastity Sue Mitchell at the Lawrence County Jail, case number CRV 24-6. Angela Badgett is on deck.
Okay, while we're looking, no, there she is. All right, ma'am, are you Chastity Sue Mitchell? All right, Ms. Mitchell, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your, what's called an arraignment hearing for you. You are appearing in the court on a television monitor, and what you say, what I say to you is all being recorded. You have a right to remain silent. You don't have to say anything if you don't want to, but what you do say is on the record, so if you admit something that's damaging to your case, the state can use it against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes.
You're charged with the theft offense. It's alleged that on December 30th in 2023 in Fayette Township, you purposely deprived. There's somebody talking in the background. I need to mute that other. Okay, I muted the other computer there. Okay, now it's not coming through. All right. We're good. Can you hear me okay?
Yes.
Okay. Your charge alleges December 30th, 2023, you tried to deprive Walmart of property without their consent. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand that charge?
Yes.
how do you wish to plead to it?
Guilty.
Guilty means you're admitting it's true, and you're waiving your rights to a trial and a lawyer. Is that what you want to do?
Yes.
Okay, I'm going to order that you take a urine screen there at the jail, and when I get the results back, I will have you back on camera to finish the sentencing. So they'll give you a urine screen there at the jail, and then I'll have you back to finish the sentencing.
Okay.
State of Ohio versus Angela Badgett, case number CRB 24-8.
Angela Badgett should be next at the jail. Ma'am, are you Angela Badgett?
Yes, sir.
Ms. Badgett, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. If you do say something, it can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, to make the state prove this charge beyond a reasonable doubt. You understand those things?
Yes, sir.
You're charged with domestic violence. Celeste, this happened on December 31st of 2023 at Perry Township, that you knowingly caused or tried to cause physical harm to Alyssa Leonard, who's either a member of your family or a member of your household. You understand that charge?
Yes, sir.
How do you wish to plead to the charge?
Not guilty.
Do you want a lawyer appointed to represent you? Do you want a lawyer appointed to represent you? Do you have a job?
No, yes, sir, yes.
Well, you're eligible for court-appointed attorney if you don't have work. You understand that?
Yes.
So probably it's smart for you to get a lawyer.
Yes, okay, yes.
All right, Mr. Morford, I'll appoint you to represent Ms. Badgett. Mr. Morford's here in the courtroom. He's heard your arraignment information. So I'm entering a not guilty plea for you. Is there a protection order requested?
No, Your Honor, Ms. Leonard is here. I believe she does not want to have a protection order.
Okay. I'm not going to order you to stay away from Ms. Leonard. She has not requested that of the court. So I'm going to release, I assume there's no objection to an OR bond.
We have no objection, Your Honor.
I'm going to release you on a signature bond of $1,000. So what that means is you're guaranteeing, you're saying you're going to sign a piece of paper that says, I promise to come to court when I'm ordered to, and if I don't show up, then I have to pay $1,000, but you don't have to post it now to get out of jail. You understand?
Yes, sir.
Okay, so now we've got to find a date when we'll come back to court for your next hearing. So what's your availability, Mr. Morford?
Judge, I'm pretty much free. I don't have any jury trials set in the near future.
Okay, let's look at the court's docket then.
We will waive time, Judge, if she's going to be out in OR bond. That'll help you with your calendar.
Well, the 12th is okay. It's 16th is even better, and the 19th is good. So there's one of those 3 dates. Do you have a preference? And
Judge, I'm here all 3, I believe.
Mr. Hill, do you have any preference?
No, Your Honor.
Let's do it the 16th then. That's a Tuesday, like, ordinarily this court's in session on Mondays and Fridays, but when there's a holiday on a Monday, then it goes to the next day. So the 15th is Martin Luther King Day, so court will be in session on the 16th, Tuesday the 16th. So that'll be the next hearing. Ms. Badgett, your next hearing date is going to be January the 16th, Tuesday. Do you have a phone number where Mr. Morford can reach you?
Yes, I do. 304.
What is it?
304.
304.
I'm sorry, it's 304-690-5171.
Judge, what was the 69?
690
690, thank you.
And then 5171.
517.
Got it. Thank you, Your Honor.
So, ma'am, you need to be at the court in Chesapeake on January the 16th at 10 a.m. Do you understand that?
Yes, sir.
All right, so be here at that time, and Mr. Morford will be here. He'll be representing you at that hearing. It'll be a pretrial.
Okay.
Do you have any questions, ma'am?
No, sir.
Okay.
I'll be in touch with you, ma'am, before we come to court.
Okay, thank you.
Thank you, Your Honor.
State of Ohio recalls Ronnie Raymond G. Tawny, case number CRB 24-4, here at the court.
Okay, you had a good computer screen. No illicit substances showed up, so that's good. You have a right to make a statement to me if you wish before I sentence you. Do you have anything you want to tell me before I decide what your sentence should be?
No, just that it was a stupid decision to have made, something I regret doing, and something I'm not gonna do again.
Okay, I'm going to read the affidavit from the, it was actually the deputy who filed the affidavit. It says, December 29th, I was dispatched to Walmart for a theft offense. I arrived with another deputy, went to loss prevention. Mary Ann Bagley, who works for Walmart, was watching two individuals on camera and advised they'd been canceling items on their person. The two in question were a male and female. Mary Ann advised the two that came together were shopping separately. She continued to watch them. The male walked past last point of sale and began walking out the door, was intercepted. The male was identified as Andrew Carr. He was placed under arrest. Searched him and retrieved Walmart property in his pockets. There was miscellaneous items that came to a value of $84.59. Advised him of his Miranda rights, stated, asked him if he was willing to talk. Female walked past the last point of sale and went to walk out the door, was intercepted by loss prevention, brought into the office. Deputy Riley took her to the other side, away from Andrew, stated they were married. Female was identified as Rainey Tawny. She had property on her person that had a value of $214.63. Rainey was transported to jail by Deputy Riley. That's pretty much it. Anything you want to say, ma'am?
Other than I regret it, you know.
All right, I'm going to impose a $100 fine where you pay the court costs, 10 days in jail, and I'll suspend all of your jail days on the condition that you do 5 days of community service. We have a community service program here at the court. Every day, starting at 7:30 a.m. till afternoon, do community service as assigned by our community service people. You can do it any day, but it's Sunday here or a holiday. So I expect you to do the 5 days in lieu of going to jail for 10 days. So it's a pretty good deal.
Yeah, absolutely.
I'm also ordering you to stay out of Walmart. So you're not allowed to go in Walmart, and that is South Point or any other Walmart. They can file trespassing charges if you go in after you have this conviction. It'll be 2 years. We'll make it level 4 probation. You're going to meet with the probation officer in his office, which is on the west side of the building. When you go out through the double doors, make a 90-degree left turn. And that counter right in front of you will be the probation office. Mr. Major will be in there. You go talk to him. He'll give you some paperwork. You have a review hearing. You've got a long time to get this done, July 1st. You get it done by July 1st, you don't even have to come back for the hearing.
The 5 days, the community service.
And your fines and court costs.
Okay.
So you get that all paid off, by then you don't have to come back for the review hearing. If you haven't got it done, you got to show up. If you don't show up, you get a warrant.
Okay.
So I don't want you to go to jail, but people do go to jail for not doing what they're ordered to do. So just do it, and you'll never see the inside of the jail.
All right.
July 1st, 9 o'clock, he's gonna give you some paperwork that'll have those dates and everything I just told you is gonna be on a judgment entry. He'll give you a copy of it before you leave today.
Okay.
Go meet with your probation officer, and then you're free to go.
All right, thank you.
You're welcome.
State of Ohio recalls Andrew Carr, case number CRB 24-7.
Well, now your screen is quite a different story.
Yes, sir.
So we've got issues we need to deal with. You're, amongst that, several other things, you tested for fentanyl, which is the most dangerous thing that's out in our community right now.
If I could have, say something, I know what I did was wrong, and I had 9 months clean and sober over here in Huntington. I have a sponsor, you know, and I fell back into it. I got a baby on the way. I have a job right here at Precision Components and Machine. You know, me and my wife has our first little place together. You know, if I given the grace and the mercy and the opportunity, I can get myself back on. I can get back down here going to AA. I can get back down here to OVP. I can get my mental health back checked. But I'm just asking for enough grace and mercy that I wouldn't lose my place, or our house that we have, or the job that the Lord's blessed me with. If
How
given
long have you been
opportunity.
at Precision?
Almost a year.
Okay. Well, they probably don't know you're doing fentanyl.
Now, they know. I've talked to them about it. They do.
They do know you're doing fentanyl still?
I mean, I haven't. What I was doing was meth and heroin. Apparently, it was cut. But
Well, you got, yeah, you tested for methamphetamine too, morphine.
I don't have nothing to
THC.
hide, Your Honor.
Here's the thing now, from what, you know, from what I know, sitting here and observing what's going on in our community, if you get any drug off the street, anything that anybody gives you off the street, even if it looks like it's a prescription pill, it could have fentanyl in it. And that's killing a lot of people. Fentanyl is 50 times stronger than heroin.
And I'm just asking for the grace and mercy that the Lord's given
Well, I
us.
want to give you grace and mercy, and I want to see you accept it and do well.
Yes,
But I'm not going to say, well, just go to some AA meetings and we'll be
No.
good. So we're going to get you into some treatment. You went to OVP before?
Yeah.
When was that?
I was doing, that's where I went for my mental health. Down there, I was actually going to Taggart, what is it called? I'm sorry, Your Honor.
Where did you go to OVP?
Right here in
Burlington?
in Huntington, where the doctor, because I was getting my prescriptions wrote out. Like, because I was going to, maybe what's that?
Were you in medically assisted treatment? Were you taking Suboxone or something like that?
I was going to get on it, and then I was going to get on the Supplicade, and then I backed out of it because I was.
Well, we need to get you back in treatment, and I'm going to have you talk with somebody from OVP that's here today, and they can do an assessment with you, maybe look at your past history, because they're going to have some records on you, what you did before.
Actually, my buddy that I work with at OVP, his wife's one of the main people at the one in Huntington. That's who referred me into it there. So I'm actually pretty good with them.
Okay, well, there's somebody for here. Ms. DeMint is here from OVP. I want you to talk with her.
Yes, sir.
We'll do an assessment with you, then I want her to see the screen. You want to come up and get it? Give you his screen. And he tested for 1, 2, 3, 4, 5 things. So, talk with Mr. Carr, and then I'm going to have you come back. We'll finalize your sentencing after you've talked with Ms. DeMint. We'll decide how we're going to go forward.
Yes, sir.
Okay? So go talk with her. We'll come back.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Rosa Hamrick, case number CRB 24-5.
Okay, so you don't have as many things, but you got, I would say, He tested for the most dangerous thing in our community. You tested for the most common thing in our community that I
Yes,
see
sir.
now. Methamphetamine is rampant in our community. So, and here's the problem. You're lucky that you didn't test for fentanyl, because if you think you're getting meth, a lot of times you get fentanyl with it.
Yes, sir.
You don't even know that you're getting fentanyl. So it's still dangerous. The long-term effects of methamphetamine are bad. It's not, if you get just that, it's probably not going to take you out immediately, but over 3 years, it's going to do a lot of damage to you if you consistently use it. So, have you ever been to treatment before?
I've done Suboxone clinic, but that was for opiate abuse.
Yeah, so this is not an opiate.
No, sir.
So, where did you go to treatment before?
I just did an outpatient in Canova at the consultation. I can't say. I'm so sorry. It's a mental health.
Do you have a West Virginia medical card?
Yes, sir.
Okay, do you have a job?
No, sir. I just recently moved back from Beckley.
Okay. Is this the right address, Bradley Road?
No, sir.
What's your correct address?
826 Virginia Avenue, Apartment U.
That's Huntington though, right?
Yes, sir.
Okay, is that in the West End or where's?
Yes. Yes, it's on the West End.
All right, Heather, do you want to talk with her?
Yes, Your Honor.
Okay, so we've got a facility in Huntington, RRG, that does West Virginia Medicaid folks. So I want you to talk with her. The only thing she tested for was methamphetamine. So talk with Heather, come back, and I'll finish up your sentencing after you talk with her and decide how we're going to go forward.
All right, thank you.
State of Ohio recalls Chastity Sue Mitchell at the Lawrence County Jail, case number CRB 24-6.
Yes.
All right, Ms. Mitchell, I got your screen back. You tested for THC only, nothing else, so I'm not going to require any treatment of you. So is there anything else you want to tell me before I sentence you? Okay. I'll impose a $100 fine and court costs, 10 days in jail, suspended. I'll give you credit for some time. How long you been? You've been in the jail now, what, 3 days?
2 days, my worth.
Okay, I'll give her credit for 4 days, suspend 6. Order you to do 5 days of community service on the court's community service program. Stay out of all Walmarts. And you'll have 2 years of probation, level 4 probation. Your review hearing will be July 1st of this year. You have to come into the court if you haven't finished what you're ordered to do, your fines and court costs and your community service. You got to show up for a hearing. If you don't show up, you get a warrant for not showing up. You get it done before July 1st, you don't even have to show up for your hearing.
Okay.
The court's in, you know where the court is in Chesapeake?
I don't, but I can find it.
Okay, it's on County Road 1, which old people like me call it old US 52. It hasn't been US 52 for a long time, but it's on County Road 1, about 1.5 miles from the 6th Street Bridge downtown to Huntington.
Okay.
So, I don't know if your microphones are not the same. Their microphones are picking up everything. Used to didn't do that. So I don't know if they changed headsets or what happened. But. Okay, so you're going to get out of jail today. July 1st is your review hearing. You can come to the court any day at 7:30 except Sunday to do community service or a holiday. You can't come on a holiday.
You said not on Sunday and not holiday?
Correct. You can do community service 6 days a week normally.
Okay.
Any questions?
Will that be on my paperwork? Because I'm having a hard time here, and I just want to make sure I get everything taken care of, so I don't want to be back here.
Yeah, we'll send it down to the jail, or you have access to a computer or a smartphone?
I do not, I'd rather have it on paper if that's possible.
Well, I'm just saying as a backup, you can call the court or you look it up online, that we have a website. And if you go, you can click on record search and put your name in, and it's going to pull up your record.
Okay, yeah, I can do that as well.
Okay, that's all.
All right, thank you.
You're welcome. I think that finished. We're finished at the jail now.
Thank you, Your Honor.
Thank you. Okay, we're starting the pretrial docket.
State of Ohio versus Stephen J. Febo, case number CRB 23-700. It's Mr. Steyer's case.
It's set for pretrial today.
Your Honor, initial discovery is done on this, but in taking a look at a statement that I guess came in later, Mr. Hill discovered that there might be an audio recording of the alleged incident, and he doesn't have that or know if it actually exists or not, so we're probably going to need to take some time to find out whether that exists, and if so, get it produced in discovery. So I don't know how long Mr. Hill thinks it would take to get that done, but we would seek a continuance to that date.
Mr. Hill, do you have some input on the time frame?
It should, well, I don't have any idea at this point, Your Honor, but we shouldn't take too long to try to get it. I mean, we'll make the inquiry immediately.
So the 16th would be a reasonable date, or are you available then, Mr. Steyer?
I'm on the docket already, Your Honor.
Okay, January 16th. So that's 2 weeks from today. January 16th will be the next hearing.
Thank you, Your Honor.
You're welcome.
State of Ohio versus William Spalding, case number TRB 23697, CRB 23512.
This is Mr. Steyer's case as a pretrial.
Your Honor, we have two matters here. One is a theft offense. I believe Mr. Spalding has entered a plea to that, but has not been sentenced. And then we have a driving under suspension. He has identified his issues in West Virginia. He paid the fine off, but still has to pay a reinstatement fee before he can get his license back.
Yeah.
And he has to secure insurance before he can get his license back. So for that reason, we've been continuing this matter. If the court will indulge us a little more time to work on that, I'd like to get him legal to drive before this goes on and potentially causes further problems.
Well, I don't see any reason to delay the sentencing on the theft offense.
No, that's fine, Your Honor.
Let's go ahead and conclude it. So he is entering a guilty plea on
Yes.
case number 23512. Looks like a Walmart shoplifting.
It is, Your Honor.
All right, well, Mr. Hill, do you have any statement you want to say or any input on that?
No, Your Honor, there's no restitution that would be requested, and we don't have any indication of prior theft offense or any aggravating circumstances.
All right, well, staying consistent, I'm going to order him to do a urine screen today before I do the sentencing. So go do a urine screen and come back, and I'll send you after I get the results.
Thank you. Step out. Someone.
Mr. Cooper's out there in the lobby.
State of Ohio versus Harold Maynard, case number CRB 23773, A and B.
This is on that TRD case.
This is Mr. Stratton's case set for a pretrial today.
Yes, Your Honor. Oh. We just heard this last week.
They're here. You don't want to pursue
So right now, we've got a protection. Okay, what I want to do, we can drop the protection order, but I'm not going to drop the case yet. It's going to be okay. I'm sure we'll come back and forth down the road to the west, make sure there haven't been any problems. We agree to dismiss it, okay? Your Honor, if you please the court, I've got the two alleged victims here, Ms. O'Brien and Ms. Maynard, and they're both urging me to dismiss the charges, saying that it's all a big misunderstanding. The allegations, though, sound, pretty severe. So we're not willing to dismiss the charges today. Ultimately, if there's no further problems, obviously that would weigh in favor of dismissing the charges in the future, but we're not ready to go there yet.
Well, I read the affidavit too. What I would like to see is maybe Mr. Maynard doing something to get his drinking under control.
And that's
14 beers, according to the officer, he admitted to him he consumed 14 beers. That's not reasonable. And that's, I would say, at the root of this problem.
Would you agree that 15 beers is too many beers?
I don't even think he had 14.
Yes, it is. Or maybe have 12. His drinking causes. No. The state agrees with the court on this. The indication is that he had a lot to drink. Now, Ms. Maynard disagrees with that, but
Well, she's probably under a lot of pressure to not agree, so I'll be the bad guy, not her. So I'd like to see him go to treatment.
Yes, Your Honor, we'll do an
Alcohol.
assessment and see what they recommend.
Does he have, how does he pay for medical
How do you
services?
pay for
I got medical card.
medical
He's got a
card?
medical card,
Yes.
okay. Taylor, you want to talk to him?
You want to recall it, Your Honor?
Yeah, let's recall it, have you talk about getting an assessment, and then we'll come back.
State of Ohio versus Darren L. Court, II, case number CRB 23761. Mr. Morris, please.
what's that?
The charges.
His charges.
This is a workman's case at a pre-trial.
I thought you said go with
There you go.
Victoria Bowman.
She wasn't even here for it. She left as soon as he got the record.
That was going to be my personal recommendation.
That's when the confusion came out. Which daughter was involved. Charlie was involved. If she had. I didn't know this was happening. I didn't ask the cops. I was trying to get his mom to get him.
Judge, I believe that the state's going to be agreeable to resolving this if Mr. Crum will go to anger management and complete it, put it on the 90-day list. If there are no further problems, it will be dismissed. We did not discuss if cost would be involved.
That's why the costs are going.
Okay.
Should he gets here.
And I understand from my client that she's going to ask the court to eliminate the no contact order.
That was also going to be my personal recommendation to enroll in anger management. And
2 years now.
I've been off my psychiatric meds since I did complete treatment. I'm not for active addiction or anything. I did a long-term prison sentence. I've been out a couple of years, so I'm still adjusting. I'm not on drugs. It's been hard for me to find a job. I had a cancer diagnosis recently. It's nothing serious. It's just skin cancer, but I've been with Tori for 5 years. I believe you know Tori. There's never been no physical violence between us. It was an argument. If you read the report, we got in an argument in Ashland, and I got out of the car as I seen it was escalating. Rather than escalate, I got out of the car, and normally she'll calm down in a couple hours and come get me. She didn't come get me, so I made my way home, and just the argument wasn't over, and we were yelling at each other. That's how the night ended, with me going to jail. But the arresting officer, Cochran, had a totally different attitude than Sergeant Sisler. When I left her house, I had a domestic charge, and he was trying to put more charges on me at the jail just for talking to him like I am you, telling him that I had an argument, I've never hit her, and just being truthful. And that is the truth. I've never placed my hands on Tori or any female.
If I may, Your Honor, the allegations are fairly accurate as far as his description of what happened. Apparently, he and Ms. Bolden had an argument over in Ashland, and he ended up having to walk home. He got home and ended up scaring the 10-year-old child who left the residence. There's no
went to the grandparents' house. Right?
Yeah.
My dad lives right beside me.
So there's no accusation of physical violence. However, it's not that this charge shouldn't have been filed and shouldn't at least be investigated further. And also, if there are some issues that maybe Mr. Mitchell could use some help with, such as anger management.
I'm Mr. Korn.
I'm sorry, Mr. Korn. As far as anger management, that kind of thing, and he mentioned substance abuse. I don't know if that's an ongoing issue or not, but that's what we would like to see, and keep the case pending, and make sure that there are no further problems in the household before we dismiss the charges. And Ms. Bolden wants the protection order dropped with respect to her daughter.
And is the state on board with that too, or?
We're on board with it if Mr. Korn wants to do the anger management council.
He does.
Yes, sir. So we're in agreement with that.
All right, sounds like from what he said, do you have a provider now that you see?
It was with United Family Recovery. I'm partial to their staff, so I do, yes.
Where's that located?
Their home office is in Cold Grove.
Okay, and were you getting, it sounds like you were on some sort of meds at one time that you're not taking now?
Yes, I was, yes.
Can you get back with your provider?
I would, yeah, I'd have to talk to a psychiatrist again and figure out a regimen.
Well, I think that's maybe important, and I see some head shaking on the other side, that maybe could help the situation, so.
That's right.
So I'm going to order you as a condition of your bond that you get back in with your provider, get back on any meds that they prescribe for you. And then we'll just see how this goes for a while. And if there's no further problems and stay satisfied that, the main thing is I don't want to see this happen anymore. I don't want I know you're minimizing it, and maybe it's not as serious as some other cases, but it was serious enough that a 10-year-old little girl felt like she needed to leave the residence and go to her grandparents' house.
Yes, sir.
So that tells me that there was a problem, because that's not what normally happens.
Right, yes, sir.
when people are disagreeing. So, in a reasonable fashion. If they're disagreeing in a reasonable fashion, it's not going to cause the child to flee the residence and go to the grandparents. So let's fix the problem. The main thing is I don't want to see you back here again, or somebody get hurt. So I would say come back in about a month. Go get with your provider, and then we're going to need some evidence of what you're doing. You know, when you come back, I want to see some proof that you've been there, what meds you're on, how things are going. And ma'am, you're welcome to be here. You're not required to be here, but it would be good to get your input too to the prosecutor before that hearing happens. So around the 1st of February, what's your schedule, Mr. Morphy?
Judge, I'm good. Whatever your calendar is.
State have any input on the date?
We're available anytime.
February 9th?
I'm here then.
Second Friday of February. February 9th for a pretrial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you.
Yes, sir.
You're welcome.
State of Ohio versus Linda L. Carpenter, case number TRC 23-1792, A and B.
And ma'am, are you Linda Carpenter?
Yes, sir.
All right, and we had set this for a pretrial today. Have you obtained a lawyer?
Supposed to be here.
Who's that?
Luke Stiles.
Luke Steyer? Okay, he is here.
Oh, sorry. I wasn't aware this was on the docket today.
Well, I didn't have you listed. Are you saying I appointed him, or no? Did you hire him?
Yeah, I
Okay.
hired him.
All right, well, why don't you go talk, and then we'll...
Can I see the file for this
Sure.
for a moment, Your Honor?
We'll recall it after you've had a chance to talk.
All right, thank you.
State of Ohio versus Devin L. Cruel, case number CRB 243. And State of Ohio recalls Alexander C. Altizer, case number CRB 24-1.
Okay, so I called these both up together because they're co-defendants, and I know you wanted some time to look at the file.
Yes, Your Honor.
How do you want to proceed?
Well, what I'd like to do is, if you need to arraign Mr. Cruel first, I guess that might be the first thing, but
Okay.
This
The only
involves-
charge I have on him is disorderly conduct, is that correct?
that's all we have at this time.
All right. Mr. Crowell, you're charged with disorderly conduct. It's a non-jailable offense. Maximum penalty is $150 fine. That alleges that Rome Township on January 1st, you caused inconvenience, annoyance, or alarm to others by engaging in fighting, threatening to do harm, being violent, or turbulent. That's the charge against you and Mr. Altizer. You understand the charge?
Yes, sir.
How do you wish to plead?
Guilty.
Okay, so they both entered guilty pleas. Do you have a recommendation, Mr. Appeals?
I do, Your Honor, and before that, I would like to also inquire about the fact that these two gentlemen were in, I guess, a fight against each other, and that's how Mr. Altizer ended up bleeding. And we're satisfied at this point just to stand with the two charges that are filed, but I actually could file an assault charge as well if Mr. Altizer felt that it was appropriate. But I also could file a resisting arrest against Mr. Altizer, even though the facts are somewhat minimal as far as the charge of resisting. So we would not have to do that if they just want to both agree not to, that if Mr. Altizer agrees that he doesn't want us to file the assault charge, I guess is what I'm driving at.
No,
I don't.
And I take it, Mr. Crewell, you don't want any other charges filed against him? They were sitting together, so that kind of gave me a clue that there,
It's just a misunderstanding, sir.
and too much alcohol.
Yes, sir.
Okay. Anything either one of you want to tell me before I finalize your sentence?
No, sir.
No, sir.
Okay, $100 fine and court costs for each of you. You need time to pay that, can you pay it today?
I could pay Friday.
I can do Thursday.
Okay, here's what I'm gonna do for both. I'll give you a final pay date of April the 9th. If you pay it before then, we're good. If you pay it after that, I'll suspend your driver's license for not paying. Or if you don't have one, you won't be able to get one for a while.
Yes, sir.
So, any questions?
No, sir.
Go to the probation office, even though I'm not putting you on probation, if you want a copy of the judgment entry, or you can get online, as I've said several times, and check your record. It'll be in the record, search record of the court's website now. Any questions?
No, sir.
Okay, so that's all you have to do, is just pay the fine, court costs, and you're done.
Thank you, sir.
Thank you.
You're welcome.
State of Ohio recalls Harold Maynard, case number CRB 23773, A and B. Harold Maynard.
Okay, Mr. Maynard was going to talk with Taylor about some substance use counseling. That's happened.
It has, Your Honor. We spoke briefly, and with his history, he really needs residential.
Okay, and I assume he's not agreeing to that.
He's not.
What's, I know, but what's, you want to inform the court about the basis for that?
He's been drinking for 29 years. He drinks after 5 o'clock at least 12 years. And even though now there's dating not every day, but even at not every day, that's still a lot of alcohol to consume, and that's a long history. I can't justify outpatient.
Okay.
Your Honor, you know, with his family situation, why don't we give outpatient a try and see if he does well on that?
Is he working or?
I got a disability,
Okay.
and I help take care of my grandkids.
Yes, his daughter works at Walmart and he helps take care of the kids. If we try outpatient and it doesn't work.
Are you willing to try outpatient, or do you think it's?
Yeah, he'll try outpatient.
No, I know he will.
Oh, okay.
Is the facility willing to try it, or is it?
I can try it, but the first time he fails a urine screen because of where he's scored in at, like I would have to be able to justify. And that would mean no slips, no late appointments, no cancellations.
That's fine.
The first time you mess up, that
That's
means
fine.
you go in.
And you agree with that?
Yes, Your Honor. He'll be on it.
And I see families agreeing with that. We're gonna give him a chance. But you gotta take this seriously. Because, I kinda suspect that maybe they've lived with some bad things over the years because of your drinking. So now's the chance to get that all cleared up and put it behind you.
Yes.
Okay, so let's come back, let's say in 3 weeks, I'm gonna give you a 3-week trial. And if you mess up, you gotta go in.
Okay.
So that's gonna be the 23rd. Are you available then, Mr. Schreck?
Your Honor, probably be the 22nd, but no.
Okay, maybe I looked at the wrong. January.
Sorry.
No, that's fine, I need corrected often.
Oh.
The 22nd. Are you available then?
No, I'm not.
Okay.
22nd, Your Honor, no.
The 19th.
Those, the 19th will be good.
All right, January 19th.
Thank you, Your Honor.
You're welcome.
Tomorrow at 10 o'clock. Okay, thanks.
Okay, you're good to go. Oh, Your Honor, we were going to address the protection order also.
Okay, I'll drop, at their request, they wanted the protection order dropped, and I'll drop it. You gotta do what you say you're gonna do, when you say you're gonna do it, okay? Come back, I don't want any excuses, I want performance.
Yes, John. All right, you gotta go. All right. Here's Sean.
State of Ohio recalls William Spalding, case number CRB 24512, TRD 23697. That's Mr. Steyer's case.
Need Mr. Steyer in the courtroom? Case numbers?
Yes.
23512, 23697. We need Mr. Steyer in the courtroom. Steyer, have you seen the screen?
I haven't seen it, but I was informed. Actually, make me speak a little bit more what I understood was correct.
If you show it to Mr. Hill and you're fine.
If I may, Your Honor, Mr. Spalding denies cocaine use, admits the marijuana use. My guess under those circumstances would be there's possibility that he got a hold of something that was tainted and was in that case lucky that it was tainted with cocaine rather than with fentanyl. But that's all I can speak to that issue.
Mr. Hill.
Well, we've seen that before, but certainly it's concerning.
Are you on any prescription medication?
Because a person never knows when it's going to be the wrong thing and the wrong dose.
No, I don't understand it. You know, whatever we got to do, I don't understand that.
Well, I can delay the sentencing and I think I'll do that. I'll just delay the sentencing, let him continue to work, since this is an issue, continue to work on getting his license back, and then we'll decide later how we're going to
I'll speak to you again.
put it off for a while.
In case I get
When
a
do they
case.
think he can have his license figured out?
How long do you think it'll take you to get that money together?
I'm on disability and I only draw so much a month, so I should have everything cleared up around the first week of March. By the time I get another check, I can finish paying.
Well, I want us to come back before then, we'll look at some other things before then. So let's come back in another month and see where we are.
Okay. Now, Your Honor, I do go in the first week of February for surgery for some stents. So, just to let you know.
So we can either go before or after that week. I'm sorry?
Is this for your heart? Or?
Yeah, I got blood clots.
I've got the 29th is a Monday, so when you say the first week of February, do you mean the week? Do you know what day it's on?
I think it's around the 5th.
So the 5th would be the following Monday.
29th is fine, January 29th.
Okay, so write that down.
Okay, pre-trials on both these cases, January 29th.
Now, I won't get
Your Honor,
my
what's the
check
case
till
number on
March.
the TRD?
Just be here anyway.
It is 23197.
Thank you.
Or, I'm sorry,
February 29th?
697.
No,
23,697.
January 29th. January 29th, 10 o'clock. Don't leave till I speak to you again, please. Thank you.
I think Mr. Steyer has to folder for another case.
I do, if I can bring that forward.
Yes. You ready to recall? Yes. All right, we're Linda Carpenter, recall, 231792.
Your Honor, I had spoken to Ms. Carpenter over the course of the holiday and knew she was set for today, and she hadn't actually retained me. She's done that now. I don't know how far in the arraignment you got before I was called in.
I think she was arraigned previously December the 4th, so I think that's
Okay.
all been completed. She entered a not guilty plea.
Okay. In that case, Your Honor, I'm going to need some time to do some discovery, take a look at the case, and familiarize myself with it. So we would ask for another pretrial a little bit down the road, and we would, of course, we waive time constraints to accomplish that.
Okay. Well, the 19th, 26th, and 29th are all good. Do you have a preference? These are all January dates.
The 26th is the lightest for me right now, so let's go with that if we could, Your Honor.
January 26th will be the next hearing. Then it'll be a pretrial 10 a.m.
Write that down on one of those if you want to. '26 at 10 a.m.
Oh, I was gonna try to keep that on. Okay, no wonder it's like, okay.
Are we okay?
Let's change it then. Let's put it to the 29th. That's Mr. Kermeen's first day as acting judge, so I don't wanna make him quit.
Gotcha. Okay, well, I've got it on the 29th. You got the change? Okay. Thank you.
You're welcome.
And we'll talk later on about getting paperwork signed and all that, okay?
Okay.
Thank you.
State of Ohio versus Trevor Dement, case number CRA 23-514, CRA 23-380, CRB 21-167, CRA 23-21, CRB 23-22, CRB 19-667, CRB 19-570.
It's Mr. Steyer's case, Mr. Dement.
May I approach?
Yes. A report from OVP Health. And it says he is compliant with the program at OVP. This is an outpatient program now.
Yes, he completed inpatient. He's now in the outpatient phase at this point, Your Honor.
And he's been there since the fall.
Yes.
Yes.
My personal feeling, knowing his history, I think we need to go longer.
Okay.
He needs to keep, he's doing well, but we need more time.
That's fine with me.
Recover. So, we've been coming about a month, let's make it 6 weeks before he comes back.
Okay, 6 weeks puts us in mid-February. Mondays or Fridays better for you, does it matter?
It don't matter.
Okay. 12th or the 16th, I'm available.
Let's do the 12th.
Sorry about last month.
February 12th will be your next hearing. Keep doing what you're doing. Good job.
February 12th, oh, that's my birthday. Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
No, you're fine.
State of Ohio versus Allen Dennison, case number CRA 21-718.
Mr. Steyer's case, preliminary hearing.
Your Honor, I believe the state subpoenaed a witness to be here today. I see if that individual's here.
Matthew Newton?
Matthew Newton.
So, Your Honor, this case originated back in 2020, and we asked for a subpoena to be issued almost a month ago, but didn't receive any response, and he's not here today, so we will nollie the charge and reserve the right to refile it if there was some good reason why we hadn't had contact with him.
We have no objection to that, Your Honor.
Right, it'll be knowledge.
Thank you.
You're welcome.
Wait, I'll come talk to you. Okay. You're free to go. Just don't wait in the lobby for me. You're welcome.
State of Ohio versus Tony Walters, case number CRA 23466, CRB 23467 A and B, CRB 2354.
Mr. Smith's case?
Yes, Your Honor, Ms. Walters I believe called courthouse as well this morning, but called my office. She's tested positive for COVID on Saturday, so I'd ask that we reschedule this, maybe to, I guess, get more than 10 days out.
Mr. Hill?
We're not opposed, Your Honor.
Are you here the 16th already, I think?
Yes, Your Honor.
16th, January 16th.
All right, thank you.
You're welcome.
State of Ohio versus Aaron Sloan, case number CRA 23368 A and B, CRB 23369, CRC 23750 A and B.
Mr. Morford's case?
Judge, has the court received a report from ARC?
And, well, not since November 28th.
Nan said she sent it. They're supposed to be here again today. Remember last month I had to call and get it sent in?
Yes.
She was supposed to have sent it again.
Check, it's not my file, so I don't.
Do you want me to have them fax it again real fast?
Yeah, let's,
Who is it?
there should be a report from ARC from Aaron Sloan.
Okay, what is it?
Okay, we'll recall it.
Thank you, Judge.
You can call them and make sure they sent it and how they sent it.
I think somebody's supposed to be here.
Okay.
The last 2 months since somebody hasn't been. I'll check on it.
State of Ohio recalls Rosa Hammer, case number CRB 245.
You okay?
Yeah, computer. Your Honor, I have her mental health assessment scheduled for tomorrow at 9 a.m.
Okay. And you can get there, Ms. Hammer?
Yes, sir.
Anything else you want to tell me before I finalize your sentencing?
I would just like to take full responsibility for my actions and just have mercy on me. I'm going through a rough time, and I'm just trying to get back on my feet to get my son home with me.
Okay. Where's your son?
He's with his dad.
Where's that?
He's in Westmoreland, but he's not letting me see him until I get on my feet.
Until what?
Until I get on my feet.
Okay. Well, this probably is a part of it, right? If you get
Yes, sir.
clean, I would say that should help.
That's what he's worried about, yes. He just wants me clean and be a better mom for my son.
Okay, how old's your son?
19 months.
Oh, wow. He's really young. Is there any kind of core orders about
No, sir,
custody or visitation or anything like that?
No, sir, we do our own thing.
Okay.
And I just as of right now, I cannot provide him with a stable home, stable environment, so he stays with his dad most of the time.
Okay, well, I think it's probably a good idea that you get clean. If you get clean and he still won't let you see your son, there's some avenues you can pursue to try to get the court to intervene.
Yes.
It would have to be the court of West Virginia.
Yes.
And if you're in Westmoreland, that's Wayne County, right? So you have to go to Wayne.
I think he's on like the line.
Right on the line?
Yeah, they're Cabell, yeah.
All right, are you working at all?
No, sir, I just moved back from Beckley.
Okay, I'm gonna make it a fine. I'm gonna make it a $100 fine, but I'll suspend 75 of it if you complete treatment.
Yes,
So
sir.
you have a $25 fine, court costs, 10 days in jail, suspended, also on the condition you complete treatment. You have 5 days of community service to do, and order to stay out of Walmart's. I'll set your first review hearing in about a month. I want to get a report on how you're doing in your treatment. Let's make it February the 9th. So that's the second Friday in February. You come back and they're going to give me a report as to how you're doing. Hopefully good.
What time, Your Honor?
9 a.m.
Thank you. Thank you, sir.
She'll need to check in with Mr. Major at the probation office. And she needs 5 days community service, 30 hours community service. Oh, that's not bad. Review hearing is February 9th.
State of Ohio versus Sarah Osborne, case number CRB 23164 A and B.
Mr. Clifford's case. This is one that we're kind of co-tracking with Children's Services, I believe.
Yes, she has a concurrent case there, Judge. She is compliant with her case plan, has a job. She's looking for a more reliable vehicle and working on a place to live. She goes back on February 8th to probate juvenile court for a review hearing on the Children's Services Division case.
Okay. How's the state want to proceed?
Well, we want to see her finish her case plan. I actually sent a message to Children's Services this morning asking for an update and haven't received one as of yet. But Mr. Morford, I believe, represents her in juvenile court. So we're okay with extending this again beyond the next hearing in juvenile court.
You said that was the 7th of February?
8th.
8th, okay.
February 8th.
Well, the 9th is a court date here. You want to come back then?
Sure.
The 9th, February 9th will be the next hearing.
Thank you, Judge.
Thank you.
You're welcome.
State of Ohio versus Stephen Carmen, case number TRC 22-2038 A and B.
Your Honor, we reset this to today for him to show proof of insurance, which he has. Is that, can you keep that?
Yes.
Yes.
All right.
Here's, where he's registered for that.
Yes, he wants one.
Here.
You might want to give the judge that one because the other one's hard to see.
Your Honor, do you need progress reports?
I'm sorry?
Do you need progress reports?
Yes.
On his own accord, Your Honor, he signed up for the driving awareness program. So he did that on his own. I don't believe that was even court ordered, but he just went out and did that himself.
Looks like you missed some sessions or something.
Yeah, he missed a couple of mental health appointments. His mental health provider has been trying to reach out to him, and he hasn't been, contacted back. He hasn't been answering the phone.
He has an insurance cards here, Your Honor, where he had a switch over from insurance, where there was a down period where he was not covered. So he does have those here with us today.
What about this, it says there's been a problem with scheduling and him getting in on some of the things he's supposed to do.
That has to do with the mental health provider getting in to see him.
Yeah, I wondered what his explanation was for that.
Yours.
Well, I didn't think that, I changed my insurance. I brought my new and old cards with me so I could show you. And there was a down period, like my lawyer said, before my new kicked in. And I knew that my insurance being down, that's why I didn't even go in until I received my new card, which was last week.
I understand what that has to do with your going to your treatment.
Your Honor, what I think he's trying to say is that he did not want to be billed for that individually.
Oh, so he's talking about some medical insurance rather than...
Yes.
I thought he was talking about his auto insurance, but I thought there was proof of that.
Oh. No, it's his medical insurance to cover his appointments. So he didn't want to go in and have to pay out of pocket for it. But now that has been...
It's straightened out now.
Straightened out now, and he has the cards here to the court to review if necessary.
Okay. All right, so we delayed sentencing for him to get proof of insurance on the vehicle at the time that this occurred, and he did furnish that, so you can show he does have proof of insurance from the time of the incident. Well, let me go through and see put this on the record is what I'm seeing, and then I'm good. It looks to me like the first reporting period started in July. The incident where he got cited was July 3rd. My first report that I see in the file is July 18th to August 3rd. And it says he came in for issues involving alcohol. He's the primary caregiver for his 9-year-old mother. He's been attending mental health sessions. Says that he has struggled with alcohol use for long term and has not dealt with his legal issues in the past. Says he needs treatment, is willing to regularly attend mental health therapy. Has been unable to do groups due to his mother having a fall. Okay, that's the first report that I see. basically September 1st through September 24th. And he had a good screen August 21st. But this report says he's not compliant. Did not screen on the following days, September 5th, September 11th, September 21st. He's not been compliant with program recommendations. He's required to attend 2 weekly AOD group sessions. It's not done so until September 22nd. He's missed screens unless he was at the office for his mental health. He has been, not reading these parts I think are relevant. He has been resistant up to this point about attending group sessions. He did attend 2 group sessions during this review period after prompting from the provider. He has remained in contact with the agency regarding his illness. Says he had dealt with some COVID issues. His mother had been hospitalized. Okay, so that's September. Good screen in September. This is just September 25th to 30th, so only 5 days. It's not been compliant with the program recommendations. This is October 4th. Client did not attend group sessions. Appears to get confused with requirements. Reports he likes mental health therapy, but at times reports he is unsure of his appointment times. He has a standing appointment weekly. That will be reviewed with him. And it looks like he was positive then for alcohol. He was given a random screen. And this report period says it was positive for alcohol. Okay. Another screen. And the next one I've got is December 4th, and it was good. So I've got a report, and this is all from amended reads. Has been compliant, had a negative screen. So that was very minimal statements on it, but it says he was compliant. Today, he had a report for December 10th through, it's only December 10th through December 16th. Has not been compliant with program recommendations. Did not meet recommended program hours. Client still needs to be working on improving scheduling and communication. That's the last report. So, and this was a test score of 209. So, I know we continue to get the insurance information, but I don't feel like he's adequately completed treatment to the point where I would say, yeah, I mean, a 20 test score, we're going to treat it like it's a low test score. I think that's what you're shooting for, right?
Well, that's what I was hoping for, yes.
Yeah. Well, I need better. I mean, when I go back and actually look at the screens, you got several of them says he's non-compliant, or not screens, but their reports. Several of them he was not compliant with what he, for that month or time frame for everything he was supposed to do. And he had a positive alcohol test in there too. Now, he didn't have any from the court, although in the past he's had some. He had one on August that was positive for marijuana with the court. So, what's the state's position on this?
About exactly the same as the court expressed, that we wanted to do better. I wonder if there are issues that don't necessarily relate to his commitment to doing it, that he just has trouble with. I don't know, but we want him to we want him to be compliant in such a way that we don't have to look at and compare his compliance and his non-compliance, and hopefully he can do better and do everything that they want him to do.
So I believe,
Here's the way I feel about it. I guess we've kind of opened, we always talk about opening the floodgates. Well, we've kind of opened the floodgates on this because I started doing this for a few people. The law in Ohio is if you test over 1.7, it's mandatory. I have to put you in jail for at least 3 days. That's what the legislature that sits in Columbus tells me I have to do.
yes.
It's not like an option, but I've kind of had the idea, and the prosecutor's gone along with it, if we can get somebody to the point where if they had a substance use problem with alcohol or whatever, that they fix that and they're not going to come back, maybe that's a better outcome if we get them to do that because they're afraid of the jail time and they'll be more committed to treatment than putting somebody in jail for 3 days if that doesn't fix their substance use problem.
Yes.
But I feel like to do that, especially with a 20 and that young guy that keeps coming back, trying to pawn off some community service from Canova, we got to watch him really close. Yeah, I don't remember his name, but I wanted to talk to you about that. But back to this case. You need to hit it out of the park before I'm going to say you don't have to go to jail. And this is not hitting it out of the park. I want to be convinced, but look, what if I go ahead and not sentence you to jail, you go out and have another one of these, kill yourself or somebody else, and then the newspaper comes in and says, we want to see what you did, Judge. Oh, he had a 20 test score, and you're supposed to give him jail, and you didn't, and now he's gone out and had another wreck and killed somebody. If you would have given him jail, well, that would have cured that problem. Now, I don't really believe that, but there's a lot of people that would, and I'd get a lot of criticism for it. So I want to be convinced that you totally dealt with this. You're just not dancing around trying to stay out of jail, but you're totally committed to changing your behavior so you're not going to be driving drunk anymore or putting anybody at risk, yourself or anyone else. And I just don't see it yet.
Well, Your Honor, he has fixed certain aspects of his life to make sure that this he does better in the future. He signed up for that driving awareness program.
I see that, which is going to be required too.
Yeah, he's situated his family life to be able to attend meetings and to do what he needs to do in the new year. And he's also got his insurance figured out and worked out so that he is not, that's not a problem.
Well, I'm not saying I won't do it, but I'm saying at this point I'm not going to do it.
Yes.
As far as not give you jail time. So I don't know, maybe it's not worth it. That's kind of the way I feel with that kid. I'm about ready to put him in jail and his dad with him. If you remember, his dad came in and was like very demonstrative because he felt like his son's getting jerked around. And he tested like 1.9 something. I mean, by all rights, he should be going to jail. So, anyway, what I want to see some stellar reports before I'll say, okay, you don't have to do jail time. Or we can finish it right now. I'll give you 3 days in jail and we're done. I mean, I'll probably still make it a part of your probation is that you continue with treatment, but if you want me not to sentence you to jail, I want glowing reports.
Yes, Your Honor.
You'll have a glowing report next time, Your Honor.
Okay. So let's pick a next time. February 9th?
Let me just check, Your Honor. This first 3 months this year are kind of crazy, so. Yes, that'll work.
February the 9th.
Your Honor, I have a question.
Yes.
If the next report isn't a compliance, would residential treatment be an option?
It's always an option.
I gave you 3 copies.
Okay.
Driving to school, like you.
Here, you can have that one back.
As a company, we just feel that's what he needs.
Okay.
Won't be necessary, Your Honor.
Well, you heard that too, so Mr. Carmen, you better step up your game. Okay.
All right, thank you.
State of Ohio versus Daniel Craig Collier, case number TRC 23448, A, B, and C. Daniel Craig Collier.
Your Honor, we were set to be here last week for Mr. Collier. His
He was in detox.
treatment provider called me and said he was in detox. I've tried to contact him this morning without luck to find out if he's still in detox or not. I have no information on his whereabouts. I would assume he is still in detox because he's not made any attempt to contact me, which he's usually been pretty good about contacting me.
Where did he go to? He was at OVP at one time. Is he at OVP now?
No, he is not from the area. He's from up in Springfield area. He actually was on his way here to go to OVP when the initial case, the initial incident happened. Then he went ahead through this court, went to OVP, completed OVP, went home, and established with a place called Rocking Horse.
Okay, I remember now.
And that's, like I said, they contacted the court last week and said that he was in detox. We set it for this week. Tried to contact him this morning. I wasn't able to get through.
Well, okay, he's got 7 days to appear, at least by
Right.
teleconference, or he's going to get a warrant.
I'll attempt to contact him again, Your Honor.
You're welcome.
State of Ohio recalls Aaron Sloan, case number CRA 23368, A and B, CRB 23369, PRC 23750, A and B.
Okay, looks like we got a report now. Okay, they say you're doing well in the program, no issues, you're in the MAT program, and you had good screens. She's already been sentenced on the ODI. What we were working on is treatment in lieu of conviction, more or less, on the felony possession charge.
Yeah, there's also an endangering charge that's still pending too, I believe.
Okay.
Yes.
Well, this is from June. Is the state satisfied, or want to keep monitoring?
Was there an indication that,
Doesn't say she's finished, it just says she's compliant.
I spoke with Christina about that last time because when it's court ordered, there's really no, they don't give an end date, it's more the individual person. And I spoke with her about it last week, and she's supposed to give me an actual date when I go back in this week to finish up and to work on finishing up. We even talked about an internship there and stuff too, so.
Okay, that would be good.
Things are going really good.
Let's come back mid-February then. Maybe by then we'll get a report that says
Right, have more of an answer.
finished up. February 12th, Mr. Morford?
That's good here, Judge.
February 12th. See you next meeting.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome.
State of Ohio recalls Andrew Carr, case number CRB 247.
All right, Mr. Carr was going to talk with Ms. Dement at OVP and come up with a plan, and then we're going to finish up his sentencing. So we have a plan.
Yes, Your Honor. I was suggesting detox, but since he has a job and everything, we got him scheduled with our outpatient office in Huntington where he was previously a patient. I did speak with them. They have him scheduled for 3:30 today. And I explained to him that I would ask you to bring him back rather quickly so that we can see how his screens are looking and everything like that. And if he continues to fail screens, he has to go to the 30-day inpatient program.
What say you, Mr. Carr?
I fully agree with everything she's saying.
Okay. So you're gonna get to your appointment today at 3:30, you can
Yes,
get
sir.
there?
Well, yeah, 4 o'clock, sorry.
Okay, well, today, you're gonna get there. Okay, let's, scheduler went off on me, let's see. The 12th of January? Yeah, I added a day, moved it over. So I think the 12th is a week from this Friday.
Yes.
Is that right? Okay, so we're gonna see you back January the 12th with and we'll get a report. You wanna stay working and outpatient, give me a good report. You're doing what you're supposed to.
All right, yes, sir.
I'll let you stay out.
Yes, sir.
If you mess up, I mean, it's too dangerous for you to continue on without getting this fixed.
I agree, sir.
Okay, we'll see you on January the 12th at 10 o'clock.
Thank you.
Thank you.
Will it be for sentencing?
That'll be for sentencing.
Your Honor, does he need to sign a bond?
He needs to sign a bond, I can have him sign a bond. You can sign a $1,000 OR bond. No, he doesn't, he's already signed, he's already got a bond, sorry. He's got a bond with Mr. Sauer, so that's good. Okay, court's adjourned. Yeah. There it is. That was it.